All right, we continue with our top story today as the Justice Department has released a heavily redacted version of the affidavit used for the FBI raid of Mar-a-Lago. Page after page. This is just a depiction. I think it's what, Tom? 38
pages.
38 pages, Katrina. And then most of that, overwhelming majority, redacted. It's been reported that even the section explaining the redactions has redactions.
All right, along with Tom and Thane, who are joining us again, we are welcoming in founding partners of law firm diGenova and Toensing, Joe Genova and Victoria Toensing. Thanks for joining us. Let's dive right back in here. Thane, I want to get your thought. We didn't really give you an opportunity to respond specifically to the comparison that we had shared of what was taken from the former president's home in Mar-a-Lago to what Hillary Clinton had in terms of email. So let's just start here. Your response to this. I think a lot of critics or cynics might say, well, sure, but he was the president and she wasn't. So isn't it, shouldn't we be looking more closely at what a former president had?
Well, Katrina, yes. In fact, he's the president, which is exactly the point Tom was making before. He is empowered to declassify those documents if he wished to. I am of the view that even if he didn't declassify them, unless there is evidence of him destroying it or disseminating it or sharing it with a foreign entity, I just don't think you prosecute a president. You certainly don't put him to jail for this. This is what, especially given the comparison that you're pointing to. But remember, there's another case that's operating today, the civil case that the president brought in order to appoint a special master to review the documents. And this graphic that you're showing me, Katrina, is evidence of why he wants a special master. Because he's saying, look at this comparison. Why would I trust the FBI or the Justice Department to rifle through my personal effects and my documents that I created while I was in the White House? Why should I possibly remember the Mueller investigation that was based on the Steele dossier? They didn't even, the FBI didn't even, in fact, do its own original investigation. So it's interesting that you're showing me this graphic because to me, it's evidence that should be used today in the argument that the president's lawyer is seeking to say, look, there has to be a special master appointed here because look at this graphic itself demonstrates that I have a very bad history with the FBI and I have no reason to trust them. I was cooperating with the National Archives people, and the next thing you know, there's an executed search warrant to go through my personal office and take out things that are personal to me that could be subject to attorney-client privilege or executive privilege. So I want to stop it and let a special master review.
Yeah, let's bring in Joe and Victoria. It looks like the magistrate punted for a week and then took exactly what the DOJ gave him and released that. Am I reading that wrong?
No, this little Nebish, who is this magistrate judge, really has shown himself to be not ready for prime time. He talked a lot about all of his fears and this and that and the other thing, and then he just basically rubber stamps the government submission. He was never going to do anything else. He was drawing attention to himself in order to dramatize his role. I think, regrettably, this redacted affidavit creates more problems and raises more questions than it answers. But it also raises the more serious question, under no circumstances should there ever have been a search warrant at a former president's home. The government should have gone in if it was having problems, asked for a hearing on the grand jury subpoena. It would have been a secret hearing. They could have had their questions answered, and an order to compel could have been issued by the federal judge.
Yeah, by the way, very quickly, Victoria, we wanted to explain to people what's on the screen. The president, the current president, by the way, Joe Biden, heading up to Wilmington, there, Marine One, obviously. We'll continue to track that if there's any news that comes out of it. That's what we're looking at right now. Victoria, go ahead. Finish your thought, please.
Yes, I just got off the phone with a member of the Trump legal team, and I was told that on June 3rd, the FBI went to Mar-a-Lago and they went through all the documents that were there. And they said, things are good, but we'll get back to you. And the next day, they got back to them and said, oh, you better put a better lock on it. June 5th, the better lock was put on. And the team had never heard from anybody in the government since that day, since June 4th, when they said put a better lock on it. So what Joe was saying, I want to reiterate. The Justice Department, Merrick Garland got up there and said, we use the least intrusive method possible to get information. No, no, no. That's called going to court if there's a problem, communicating with the lawyers, not issuing a search warrant. But it seems to be that a search warrant is the Department of Justice's weapon of choice these days.
Yeah, and Tom, I know that you have some things to add to this, so I'll just let you take it away.
Yeah, sure. And to Victoria's point, on June 8th, and if you look at this document, page 22, page 23, on June 8th, the Department of Justice counsel sent a note to the counsel to former President Trump saying, you know, it needs to be in a secure location, authorized for the storage of classified information, and that goes on. They include that, but then they redacted the Trump counsel's response to the Department of Justice. So we're not really getting the Trump side of the story here.
Can you show that page?
It's all blacked out.
Show where that is.
So this is,
as we showed this,
2023. So this is the DOJ communication, and this is the Trump lawyers' communication back to the Department of Justice with some sort of explanation. And why this is important is because they're going to really try to hang their hat, I believe, on obstruction of justice. And so I think, you know, the Trump folks are very concerned about the fact that so much of this is heavily redacted. They have this letter. Maybe they should consider releasing the letter
Could they
to
release it?
DOJ. Absolutely, if they wanted to.
even if they violated what the tenets were that was at the beginning of the document, where they say we don't want to release people's information on certain people.
Well, I mean, they could certainly, if there
have a
were
couple
names,
redactions here.
have some redactions.
Yeah.
But basically, you know, we've been talking for months about how, with the January 6th committee, the Trump side of the story has not been given an opportunity to have a hearing. Well, here, in the way that DOJ redacted this, the Trump side of the story is also not been presented to the public at all. So this is something that the president and his attorneys probably could control, because they obviously had a communication with DOJ as that negotiation was going on, and I think that it would be very informative to try and figure out, you know, to get that information.
Yeah, so there's more that we potentially could be seeing, but from the Trump side.
Right.
All right, team, thanks so much. Joe and Victoria, thanks for being with us, and of course, Tom and Thane.